Okay, good evening and thanks for coming to class. Tonight we're going to look at consumer protection law. And if you remember a few weeks ago we were talking about product liability law. And if you remember and again, this is a body of law that covers not just products, goods if you will, but also transactions for services, real estate, insurance, employment, all that kind of stuff. But if you remember a few weeks ago when we were looking at product liability law, we realized the product liability law was pretty much this. If enough product manufacturers are sued enough times, they will start making safer products, right? They'll get the point, right? They're sued so many times, then they will get it, right? They'll make safer products for kids, adults, it doesn't matter. Okay, this is a little bit different. Whereas product liability law was treatment law, right? You buy the thing, rips your face off, then you sue the manufacturer. We're trying to prevent some of these problems, okay? But we're not just trying to prevent problems in regard to products. We are trying to prevent problems that might be associated with purchases of services, right? Transactions in real estate, employment, insurance, you get the idea. So if you remember from even further back when we were talking about contracts, the difference between the common law and contracts in the UCC. This is a body of law that will cover virtually everything, okay? Now, however, as we go through this, right, kind of tying a lot of this together, in many situations where you're talking about products, goods, you might have a consumer protection claim, a breach of contract claim, as well as a product liability claim, all right? So just kind of keep that in mind. You don't necessarily have to separate these and put these bodies of law in separate boxes, separate silos, if you will. They often interact with each other. Okay, so what is consumer protection law? Well, it's really a body of law that's made up of statutes, administrative rules, as well as judicial law, right, common law, that protect consumers before the transaction takes place. That is to say, we've given all these consumers essentially behind the scenes this protection. So the idea is when it's on the shelf, right, the product is on the shelf, or you're looking at a service online, it's safe, right? There's been a lot done before the point of retail whereby these products, services, etc. Are safe. Now, getting back again to product liability law, if you remember, we'd spent a lot of time talking about the laissez-faire doctrine and basically buyer beware. Things have shifted over time. Over the last 30 years, really 40 years, consumers have become much more aggressive. They've become much more litigious, certainly in regard to product liability law, but they've also contacted their member of Congress, the member of the state assembly, right, in Ohio, the Ohio General Assembly, and said, look, I need greater protection even before this stuff gets out into the stream of commerce. So the attitude has really changed considerably. And this body of law, whether it be state or federal law, statutes, administrative rules, common law, protects consumers against all types of deceptive trade practices, unfair trade practices, deceptive advertising, that kind of thing. And certainly in regard to product safety, all right? So again, there's a lot of law that we're talking about here. So what I thought we'd do is we'd kind of break it down into a few areas, starting with deceptive advertising. Now, it's just a couple of days before Black Friday, so I think this probably is a very salient body of law at this point. Now, what we're going to do is look at just three smaller areas of deceptive advertising, but start discussing the mega statute at the federal level, and that is the Federal Trade Act of 1914. One of the oldest statutes to protect consumers, probably the most powerful. It also has with it one of the most powerful administrative agencies, the Federal Trade Commission. You can't pick up the Wall Street Journal or the Financial Times and not have a sighting, so to speak, of the Federal Trade Commission, all right? But it has very broad goals, two very broad goals. One, protecting consumers from unfair trade practices, and two, protecting consumers from deceptive advertising. Now, when it comes to defining deceptive advertising, admittedly, it's somewhat difficult. But you can certainly guarantee that any definition includes misinformation. Okay, so what we're not going to do is allow retailers, wholesalers, producers of goods and services to mislead consumers. So no matter whatever definition you want to use, you can bank on the fact that misinformation is going to be part of it. Okay, now for those of you that are marketing majors or advertising majors, you are allowed to engage in puffery. All right, if you remember back from tort law, we were talking about this puffery. Oh, I'm the best salesperson in the business, and I would always give you the best deal on this piece of real estate. Our goods are always the best goods in town, that type of thing. Yeah, that you can always do, all right? But misinformation is a little bit different. Having something on your product promising a particular level of safety and knowing that is simply not true would be a form of deceptive advertising. Now, if you're scratching your head and thinking, now wait a minute, that could also be a breach of contract. Absolutely. If it leads to injury later on, could it be product liability? Certainly could be product liability. Now, notice up front the difference, right? With product liability, you got to have an injury, right? With consumer protection, you just have to be misled, right? Either intentionally or negligently. Okay, so with that said, let's look at a couple of the issues that come up most often. And again, for those of you that are marketing majors or advertising majors, you might find this stuff pretty funny. Okay, so number one, half-truths. All right, half-truths are illegal. They're considered a deceptive form of advertising, right? An unfair trade practice, okay? So there's kind of a legendary case involving this Campbell Soup Company, where the Campbell Soup Company advertised that their soups were, and I'm just quoting here, low in fat and cholesterol and therefore helpful in fighting heart disease. Now, a lot of that's true. Not much fat, right? Not much cholesterol. And if you don't have those things, well, that certainly helps protect against heart disease. The problem is that their canned soups were so high in sodium that it had just the opposite effect. And I think it's kind of a commonly known danger that a high salt content, a high sodium content is not healthy and not good for your heart. So nonetheless, that kind of a half-truth will always be seen as deceptive advertising. So if what you're saying about your product better be completely true, all right? It needs to be a whole truth, if you will. All right, now very much related to the shopping season as we get closer to Black Friday here, just a couple of days away. Bait and switch, all right? Now, bait and switch activities, I'd say a couple things. Number one, they've been taking place for decades. Probably longer than that. And two, it still takes place. The question, of course, is what are you going to do about it? Okay. Now, one of the things to keep in mind as we move forward with anything that's governed by the Federal Trade Commission is that there is not necessarily a private right of action. Now, we're not going to get into the entire Federal Trade Commission set of rules, but the one thing to keep in mind is with most of them, there's not a private right of action. The consumer's remedy, if you will, is really just contacting the Federal Trade Commission and hoping something will happen, and we'll talk more about them a little bit later, okay? But essentially, bait and switch is just what you would think. You advertise a very low-cost item, and you being the retailer, know that you're pretty sure it's not going to be available. You've got two of them, all right? And you haven't told consumers there are only two of them, right? So you have this low-priced big screen TV, right? It's Black Friday, everybody wants a big screen TV. People are probably, it's Wednesday night, the night before Thanksgiving, so people are probably lining up right as we speak. Maybe even last night, I'm not sure. Okay, but nonetheless, low price, big screen television, right? You've only got two. They sell out. Okay? Now, that's not necessarily illegal, right? What you're trying to do as the retailers to draw consumers in, that's not necessarily illegal. It becomes illegal when two other things happen, all right? Number one, you're not willing to make the product available within a reasonable time period, okay? So, somebody comes in, says, I want the low-cost big screen television. We don't have any. That's bad. If you say, hey, we'll have it to you quickly. We can get it to you in a couple of days. Maybe we can get it to you in a week. That's probably going to be fine, right? You can draw customers in, but you have to take care of them once they're there, all right? And secondly, if you really kind of fight the consumer on a rain check, all right, allowing the consumer to get a rain check, that's also going to be a deceptive trade practice, a form of bait and switch, and therefore illegal, okay? Now, bait and switch, of course, is an FTC action, so your remedy is really to contact the Federal Trade Commission. Now, most retailers, wholesalers as well, know that most consumers aren't going to take that kind of time, and they're probably just going to maybe sound off an expletive and just kind of leave the store or be upset or contact the manager, and they don't necessarily know their rights. Now, it's not to say that if you do file a complaint with the Federal Trade Commission, they'll act on it immediately, but if they get enough of them, they will act, right? Some of your big box stores have been routine offenders of this. Okay, so what can we say about the Federal Trade Commission? We're going to look more narrowly at FTC actions. All right, well, the Federal Trade Commission, again, they have to get complaints. There's no private right of action under the enabling statute that created the Federal Trade Commission. So what happens? Well, first of all, they have to get a complaint. Now, they generally get complaints from 5 groups. I'd say this would be the top 5. Certainly from consumers. Certainly from consumer groups, all right? And again, there are a lot of consumer groups, consumer advocacy groups. The Better Business Bureau, all right? They do get some complaints from trade associations, all right? But number 1, competitors. Okay, so if there is a bait and switch activity, right, or some other form of deceptive advertising, a half-truth that's out there, the number 1 source of FTC complaints is going to be the competitors, so Target and Walmart, right? Best Buy and some of the other big box stores that deliver big screen TVs and appliances and things like that. There aren't really nearly as many as there once was. Okay, but nonetheless, if the Federal Trade Commission gets enough action, enough complaints, they will take action. All right. If they believe that there's some truth to these allegations, they will contact the alleged violator and then maybe also try to get them to settle. All right, and that's really just kind of a voluntary change of behavior. Don't do this again, that type of thing. However, if there is no settlement, let's say the transgressor, the retailer or the wholesaler just says, no, what we think we're doing is fine. It's not a half-truth. It's not bait and switch. Well, there are 4 things that they can do, and there's really kind of a first 3 and then the 4th one, they can do all things. Or mix these together rather. Number 1, they can engage in a cease and desist order, which is basically an order saying from the administrative law judge with the Federal Trade Commission, you simply just cannot do this anymore, okay? So it's a form of injunction, right? And of course, if you violate an injunction, that does become a crime. Number 2, counter-advertising. So not only is a cease and desist order possible, but also counter-advertise. So not only stop doing this, but with the counter-advertising order, you must advertise anew, basically correcting the misinformation you have out there. Now, if it's just cease and desist, as you can imagine, well, many consumers may not have even heard of the first message, so you're probably okay. But with counter-advertising, you're reminding, right, as the retailer, if you're forced to do this, you're reminding the consumer public that, yeah, I was wrong once, and now I got to tell you I'm wrong, and this is what the real action is. Now, interestingly enough, what's going on right now with the big tobacco companies, they're under a counter-advertising order right now, and you might be seeing some of this on the internet and on television, kind of correcting some of the misinformation. Okay, now, a third, and perhaps the most drastic, assuming we kind of put the 4th one aside for a second, is a multiple product order, which if issued against a retailer or wholesaler, can't advertise anything. Right? So it's not cease and desist where you just stop what you were doing. Counter-advertising where you got to stop what you're doing and also kind of remind people what the real information is. Here, you basically can't stop or you need to stop advertising not only that product, but any product, right? Any of the retailers' products. So it can be pretty punitive. All right, and then 4 is kind of a catch-all. So you can have all 3, and I guess to a certain degree I kind of gave it away. But if you're going to get a counter advertising order, it's probably going to come with a cease and desist. If you get a multiple product order, you may or may not have a counter advertising order, but it almost always comes with a cease and desist. So again, cease and desist, counter advertising, multiple product order, or number 4, mix and match, right? The Federal Trade Commission puts all of them together. Okay, so that's deceptive advertising. Now the next few areas of law that we're going to look at certainly include elements of deceptive advertising. So just kind of keep that in the back of your head as we move forward. Okay, so let's take a look at telemarketing. Now, telemarketing's been around for quite some time. You have telephones, you can have telephone marketing. And just when you think that, with the advent of cell phones and people giving up landlines, telemarketing just isn't going to be relevant anymore, and you don't have to worry about that telemarketer at dinner time interrupting family hour or something like that. Well, number 1, not many people have traditional dinners anymore. And 2, they're still getting to your cell phones. So these 2 statutes that were actually crafted by Congress in response to a lot of anger, those consumer groups, consumers contacting members of Congress saying, hey, you got to do something to protect me from these phone calls. They're as relevant now as they were today. Okay, so if you look at the 1991 statute, the the Telephone Consumer Protection Act of 1991, it prohibits 2 things from the get-go. Number 1, the use of a pre-recorded voice, and 2, an automated dialing machine. Now, if you're scratching your head thinking, my gosh, Tudor, I hear this all the time. Yes. Is this statute violated all the time? Yes, it's violated all the time. So you're not allowed to use, as a telemarketing firm, a pre-recorded voice in an automatic machine. Happens all the time. If you get one of these, most of us, myself included, when I had a landline, I no longer have a landline, or my cell phone, you just hang up. You're probably not going to go out of your way to file a lawsuit. Okay, now this statute's a little bit different. It is governed by the Federal Communications Commission, the FCC, and there is a private right of action. You can directly sue for a violation of the 1991 statute. 2 problems. Number 1, it's time consuming, and again, most of us are just going to hang up. And 2, what are your damages? So you have to show, just if you remember in the other areas of law that we've looked at so far, you have to show that you're injured and you're harmed. Well, you just had to listen to a couple of comments and quotes from a telemarketer, and that's probably not going to yield you a whole lot. Now, there are some statutory damages listed in the statute, but generally it's not worthwhile. Where you do see the statute enforced is where consumer groups will get together and hire an attorney, and an attorney takes all these complaints together, and that's happened a few times over the past. All right, last thing associated with the 1991 statute, fax machines, right? You can't use a fax machine if you're a telemarketing firm without permission. And when fax machines were just kind of coming around, maybe late 1980s, used all the way through the 90s, and still used today. I mean, it's not a dead technology, but you had to have permission, and of course almost no firm or person was going to give permission to a telemarketer to use their fax machine. But again, not many people did anything. You just kind of pull out the advertisement from the fax machine, you throw it away, and you're done. Okay, now let's look at the 1994 statute dealing with telemarketing, the Telemarketing and Consumer Fraud and Protection Act. Now, this statute is governed by the Federal Trade Commission, so there's no private right of action. You can't sue directly for these kinds of violations. But what it did is it really kind of gave telemarketers a how-to, right? What you have to do in terms of telemarketing All right, and still stay on the good side of the law, at least as they drew it up. Okay, so you can imagine a telemarketer, the most important thing to them is the sales pitch. How good this thing is, what it's going to do to improve your life, how good these steaks taste, right? How good is this vacuum cleaner, that kind of thing. Okay, 4 pieces of information have to be delivered to the consumer before you get to the sales pitch. All right, how good it is, how it's going to improve your life, what it can do for you, how young it can make you look, or how good it can make you feel. Okay, number 1, you have to tell the recipient of the phone call that this is a sales call. Now that might just turn them off right away. All right, 2, you have to identify the seller. Now if it's a telemarketing firm, it may not actually be the party selling the product, but firms that are big enough to have their own telemarketing outfits, they'll probably have their own. But nonetheless, you guys say who the seller is. 3, you have to identify the product sold, right? And that's the product and anything that comes with that product that might be part of the sales price. And lastly, the total cost of the goods. So if you think of, hey, this is a sales call, this is who's selling it, this is what we're selling, right? And this is the total cost, but hey, it's so great and it's going to improve your life and make you look younger, make you feel better, that kind of thing. It might kill it. And Congress, of course, knew that. I'm sure they had lots of people testifying who are experts in consumer behavior saying, you know, this will pretty much do it. If step 1 didn't do it, hey, this is a sales call, didn't do it in the first place. Okay, now after the sales pitch, so you have to do those 4 things, then you can give the sales pitch. The next thing you have to do is let the recipient of the phone call know all the material terms and conditions of the transaction. So whether it's final, whether it's refundable, all the material terms and conditions. Again, part 4, right, that list of 4 things you have to do before you deliver the sales pitch should encompass really what you need in terms of terms and conditions, but if there's anything thereafter, so this is the price of it, this is shipping and handling, this is any other associated costs, and of course if there's anything else in the terms and conditions they have to let you know. It sounds a lot like the truth in lending statute we're going to look at later in this chapter. Okay, so let's look at labeling and packaging. Now, if you remember, we spent some time already looking at labeling and packaging in regard to contracts for the sale of goods, okay? And more narrowly, we're looking at express warranties and implied warranties that are associated. But a lot of that contract law, frankly, is treatment law, right? The idea is you've bought the product, it's injured you, or you're suffering a loss or something of that nature, then you go file a lawsuit, okay? This is different. We're assuming all the safety, all the precautions have taken place before that product winds up on the shelf. Now, admittedly, a lot of this deals with goods. I mean, there is some foray into services and retail practices and wholesale practices, but for the most part, we're going to stay out of those things. But really, what you're looking at is with the statutes we're looking at here, looking at the box. What does it say? Is it truthful? What's on the box? Is the content? Raw materials, percentages of raw materials are considered percentages. Okay, let's look at the Fair Packaging and Labeling Act. All right. Now, this is the first statute, and I'm old enough now at almost 49 years old to remember when there just wasn't much in the way of consumer protection in regard to what was on the packaging of any good, let alone a food item. Okay, but this statute, for the most part, was designed to protect us as we bought food products, goods that we're going to eat, that type of thing. Okay, number 1, it has to identify the product, and that's pretty easy because marketers and advertisers will want to do that anyway. But 2, the net quantity of the contents. How much are you getting? Right? There should be no mystery as to how much you're getting in that particular box or container or bottle of water or what have you. 3rd, especially in regard to food products, the quantity of servings. Now, admittedly, the Federal Food Drug Administration dictates what a serving is, but the Federal Trade Commission also has some jurisdiction here as well. Number 4, the manufacturer, and number 5, the distributor. Now, the distributor may also, by the way, be the packager. Now, the last 2, identifying the manufacturer and the distributor and or The packager is important in case we have some illness, right? So we can track this particular lot, L-O-T, lot of goods, and we can kind of go backwards in the stream of commerce and find out maybe at what time this batch was made, when it was made, and see why people might have become sick. Okay, and then lastly, fat content. Okay, now the statute's obviously been amended several times to get narrower and narrower on fat, but under the statute now, of course, is not only how much fat, all right, per gram, but also saturated versus unsaturated. Okay, now many states have requirements on trans fat. Okay, so again, don't forget there's a lot of state law here. Okay, now the next statute is the Nutrition Labeling and Education Act. Now this statute went a little bit further. The first statute, really kind of what's in it, that kind of thing. This really deals with claims. If you're saying that your product is new and improved, well, it needs to be new and it needs to be improved, right? You can't advertise something, whether it's a food product or laundry detergent, as new and improved unless it really is new and it has been improved, all right? But things like fresh, well, how fresh? Low fat, well, how low fat? Okay? If you think about diet, right? What's diet? Okay, is it anything less than, if you think about a can of Pepsi. A can of Pepsi generally has 140 or 150 calories, and Coke has the other one. So one's 140, one's 150. I can't remember which. And of course, everybody knows what Diet Coke is and Diet Pepsi, right? 0 calories. Well, what if you advertise something as low calorie? Well, is that no, or is that closer to here? Can it be 75 calories? Years ago, there were products that were advertised in the 80s. I think Pepsi Light was one of them, and it was somewhere in the middle. I don't think you really find them too much now. It looks like the market is either they want high test. Actually, I'd probably argue that the newer niche, of course, is the pure sugar soda drinks. But you don't find much in the middle. But this claim about low calorie, chances are if you're somewhere in the middle, say 70 or 75 calories, that's not going to be low calorie. It's going to have to be something like 10, 5, 15, somewhere in there. Okay, let's look at sales transactions. Okay, now, here what we're looking at is really the dynamic between the seller and the buyer, the interplay, the social behavior that takes place. Now, again, it could be door-to-door, as we're going to look at here, or over the telephone or mail order or something like that. And we're looking at protecting the consumer from this type of social pressure that might be just a little bit too much and the buyer's in a disadvantaged situation. But the scope is much broader than some of the things we've looked at so far, especially in regard to telemarketing. Now, again, what we're looking at here are also FTC rules, all right? So the Federal Trade Commission, remember, there's no private right of action. Now, when we get into these particular areas, think broadly, all right? So it's not just necessarily a transaction that's initiated in one way. It could be a transaction that's initiated both ways. And as we go through this, I think you'll see that. So let's look at door-to-door sales. Now, most of the time, door-to-door sales are initiated by the seller, right, or the sales representative going door to door. This was a big thing, of course, in the 20s, 30s, 40s, 50s, and really through the 1970s. I'm old enough again to remember when people would go door to door and sell things. However, it could be the other way. So if a buyer says, hey, yes, come by and show me this product. Come by and demonstrate the use of this product. That's two-way. That's different. That's different than the telemarketing statutes, for instance, we were looking at, whereby I'm the telemarketer, I pick up you and pick up the phone to talk to you, and you didn't ask me to do that at all. Right? Okay, so let's look at door-to-door sales. It doesn't matter who initiated. It could be one way or the other. It doesn't have to be necessarily the seller. Now, The reason why we want to protect buyers from door-to-door sales transactions or anything that might go wrong there, the social pressure, is that this can be high pressure. It tends to be one-on-one. There are very few repeat sales through door-to-door transactions, so the sales representative doesn't have a huge incentive to cultivate a real positive long-term relationship, just a positive short-term relationship, get the product sold, and the transaction may take place right there. So it's no, well, I'll pay you later or bill you later, some things like that. Everything might be taken care of right there. It's not to say that a credit transaction might not occur, but again, the payment's already in the works. So the question becomes, how do we protect the consumer here? Well, we generally do two things. Okay, number one, we are going to give the buyer 3 days to rescind the contract unilaterally, right? So the idea is that I was in the moment, I was pressured, I said yes, I bought the thing, whatever the thing is, but now I want out of it. All right, now I've realized it wasn't such a good idea. All right, now you can imagine the abuses through the 20s, 30s, 40s, 50s, and through the 1970s, but this is still a problem today. Now, the rules here have been amended to also require that all material information, including the sales pitch, prices, delivery terms, things like that, all be delivered in Spanish. Okay, this is a bilingual country, right? A bilingual society. And there are some areas of this country that you could argue are trilingual, right? Okay, but nonetheless, Spanish is really the only rule that we have to look at this point. So again, if you're targeting, and I'm not using the term targeting in a negative sense, but if that's your target market, it's a predominantly Spanish-speaking neighborhood, your sales force does need to be bilingual, or at least if you're sending somebody out to work in a predominantly Spanish-speaking neighborhood, they at least need to know Spanish. Maybe, I guess, to a certain degree, they don't need to know English, but nonetheless, that is a form of protection. All right. So again, 3 days to rescind the contract. Now, most states do the exact same thing. All right, and state law varies generally from 2 to 3 days. I'm sure there's some exceptions other than that. Okay, but again, door-to-door sales transactions, still a lot of state law protecting consumers. Okay, now telephone and mail orders. Now, this is a little bit different in the sense that, unlike with the telemarketing, all right, getting back to what we just kind of discussed, but keeping it fresh in your head, telemarketing statutes narrowly address the situation. I'm the telemarketer, I call you, you didn't ask for it. This is different. Let's say you see something you want to buy on television and you make a phone call to do it. You see something online, right? And you want to buy it, maybe through Amazon or half.com, right? You're going to buy your law books, right? This could go either way, okay? Now, the reason we want to protect consumers here is because of the distance, right, between where the products are, warehoused, made, etc., and the consumer, whereby when they're sent and they're already paid for, well, where do I go to make a complaint? Where do I go to return the goods? Now, there's some firms that are actually, frankly, quite good at this and they'll say, hey, just return the thing. Others, not so much. And again, through the 1980s, there was certainly a lot of abuse, especially when we look at the Postal Reorganization Act of 1970. Okay, now essentially, what takes place here is really the same things associated with door-to-door sales. 3 days to rescind, okay? Any material terms and conditions of the sale, cost, what's in it, what's associated with it, delivery times, need to be addressed at the point of sale.